Bamford is Fellow-in-Law at Queen's College, Oxford. He was elected member of Oxford University's Council from October 2006 to March 2010, and an ex officio member while serving as the University Junior Proctor from 2010 to 2011. He has twice been visiting Hauser Global Research Fellow at New York University, and his talk is Comparative Authority in Constitutional Litigation.
Thank you very much. Well, like Cheryl and Paul, perhaps I can express my thanks to the organisers for putting on such a wonderful 3-day event as this. It really has been a great pleasure to take part in this conference. I want to talk about a controversy which has arisen in many jurisdictions around the world, but in particular has affected Indian constitutional law, namely the extent to which it is or should be permissible for courts to cite authority from other jurisdictions when reaching determinations in constitutional cases. Now, I should stress, and I will stress throughout, that I believe this debate is highlighted by two features. The first is what might be called exaggeration or perhaps excessive concern on the part both of opponents and defenders of comparative citation about what is happening. And secondly, the diversity of attitudes, indeed the extent of sheer opposition there is within national legal systems about whether the use of overseas authority should or should not take place. Now, I'm going to start by analysing in some depth the NAS Foundation and Delhi litigation within India, but I want to go on and compare that with the long-standing controversy in US constitutional law concerning these topics, and having done that, at least if time permits, to draw some comparative conclusions which will lead me to the point that there is rather a lot of exaggeration and division of view in this debate, and that while exchanges of judicial view and use of comparative authority is probably a good thing, nonetheless we need to be somewhat careful about the distinct structural features of different societies' constitutions when we carry out that process. So to begin with the NAS Foundation case, as everyone is doubtless aware, after a long gap, the Supreme Court reversed the Delhi High Court opinion in NAS Foundation concerning the unconstitutionality of Section 377 of the Indian Penal Code, the provision which criminalized sodomy between men. Now, at paragraph 52 of its judgment, the Supreme Court asserted in somewhat rhetorical terms that in its anxiety to protect the so-called rights, the term used by the court, of LGBT persons, and to declare that Section 377 violates the right to privacy, autonomy and dignity, the High Court has extensively relied upon the judgments of other jurisdictions. Though these judgments shed considerable light on various aspects of this right and are informative in relation to the plight of sexual minorities, we feel that they cannot be applied blindfolded for deciding the constitutionality of the law enacted by the Indian legislature. And the court cited Singh and State of Uttar Pradesh, and the quote from the judgment there, that we have grave doubts about the expediency of transplanting Western experience in our country. Social conditions are different, and so also, apparently, the general intellectual level. Specific references were then made to the practical situation, the Singh case was about the death penalty, regarding the application of the death penalty in India, and the specific conclusions of the Indian Law Commission. So on this basis, the Supreme Court was able to move to the conclusion that Section 377 was not unconstitutional. Now, I think that there are 2 points which are of interest in paragraph 52 of the Supreme Court's judgment. The first point is its characterization of the High Court as having extensively relied upon the judgments of other jurisdictions. Extensively relied would seem to imply that those judgments played a major, if not a decisive, role in the judgment at High Court level, that Section 377 was unconstitutional. Now, it's interesting to observe at this stage that the phrase extensively relied is very strongly analogous to the critiques frequently deployed by Justice Scalia in the US Supreme Court, particularly in the Lawrence and Texas case, concerning the same subject matter as NAS, about the extent to which the majority in those cases relied on overseas authority. His characterization very much is that overseas authority is driving the majority judgments in the cases in which he dissents. So it's interesting to see a similar phrase used by the Supreme Court in NAS. The other interesting phrase, I think, in paragraph 52 in NAS Foundation, is the notion that the High Court had been applying overseas authority blindfolded when deciding the constitutionality of Indian legislation. Now, it isn't made particularly clear what is meant by blindfolded. I assume it means without reference to constitutional history, social context, and so forth. But this in turn echoes a well-known criticism of the use of comparative authority, namely that it takes situations out of context and ends up applying them somewhat randomly when shifting them from one jurisdiction to another in order to decide a case. Now, we can see then that the Supreme Court's judgment is couched in rather strong terms. The question really is how far it presents a fair assessment of what was in fact being reasoned at High Court level in the NAS case. I'd like to argue that a close analysis of Chief Justice Muralinda's judgment at High Court of Delhi stage in NAS in fact reveals that non-Indian material was used at High Court stage to variable extents in different parts of the judgment. And in fact, I think we could say that there are probably at least 3, maybe more, different techniques in play at High Court stage in NAS. Certainly, there are situations in which overseas authority seems to form the direct foundation for conclusions concerning the constitutionality of Section 377, whether in terms of Article 14, Article 51, or Article 21 of the Constitution. However, there are many other scenarios in which overseas authority is used simply as a context setter, simply as background, then to go on and explain the Indian jurisprudence. And thirdly, there are examples of situations in which the overseas authority is presented as an explanatory tactic for then showing how Indian courts have used those cases. In other words, under this third heading, what the High Court was doing was drawing close attention to the fact that there is, in practice, a long history in Indian law of using overseas authority, and was deploying examples of cases where this has happened, and simply was going further, if you like, showing it's done its homework, by bringing into play the original cases from overseas as well. Now, I don't have time to go through every aspect of the judgment at High Court level, but the following few examples may help illustrate these points. When discussing Article 21, whether there had been a violation of the right to dignity, autonomy, and privacy, the High Court is careful to use the test from Maneka Gandhi and Union of India, accurately described by Aaron Thiruvengadam as a case in which transjudicial influence played a significant role, as a basis for explaining not only the role of overseas authority in Indian constitutional case law, but to show that overseas authority and the Gandhi test have been applied extensively in subsequent cases. Now, dignity is then, as is privacy, explained by reference to overseas cases, but these are then compared to the position within the Indian Constitution, even in the case of privacy, in terms of the absence of an express declaration of privacy within the constitutional provisions. In addition, the court explains the development of the right to privacy in US case law, quote, as these cases have been adverted to in decisions of our, i.e. the Indian, Supreme Court, unquote. And this is then followed by a lengthy discussion of the Indian jurisprudence as it has developed, with occasional reference to US cases as those were taken on board historically in the Indian case law. Now, admittedly, later sections of the judgment clearly do rely on cases from South Africa, Canada, and the United States, particularly this is in relation to the assessment of Article 14 and Article 15, when reaching conclusions concerning the constitutionality of Section 377. But, as I hope is clear already, in fact, these citations are playing variable and sometimes relatively weak roles in the court's judgment. It all depends which part of the judgment you're in, which of the three different tactics I highlighted, in fact, is in play. And very interestingly here, at the end of the High Court's judgment, when the court is assessing the appropriate limits to the judicial role within the Indian Constitution, it observes that the court should be a counter-majoritarian force within society, and so could intervene in the case under consideration. Now, it begins, when doing so, by citing one UK case, one US case, and a US academic article. But it also cites a very large number of Indian cases. At the very end of the judgment, in paragraphs 130 and 131, we then find reference to the spirit of inclusiveness in the Indian Constitution, the notion that statutory law should not be held captive by popular prejudices against minorities, and by extensive reference to debate in the Constituent Assembly. These are clearly not comparative factors, and yet they fall at the very end of the judgment when discussing the limits to the High Court's role. Now, I think we can say from this, all things considered, that comparatively speaking, clearly the High Court of Delhi judgment does make more expansive use of overseas case law and material than one finds typically in US Supreme Court cases. And in a moment I'll present Lawrence and Texas as an example of this. However, this usage was clearly frequently combined with discussion of Indian case law, and the very end of the judgment is appealing specifically to the spirit of the Indian Constitution. So I think this very strongly begs the question whether the Supreme Court's characterization of the High Court judgment was in reality an accurate or fair characterization. In fact, there appear to be at least the three tactics I've described in play at High Court level. So to that extent, I think we can say that the NAS Foundation saga at High Court and Supreme Court level is an example both of the variable ways in which comparative authority can be used, and in addition, clearly the ability of the use of comparative authority to provoke very strongly worded counter-reactions. Now, turning as a comparison to developments in the United States, the direct parallel to NAS Foundation is, of course, the Supreme Court decision in Lawrence and Texas, the case which held that a state-level anti-sodomy statute, again, was unconstitutional in terms of the Due Process Clause. Now, Lawrence and Texas involved a sweeping dissent by Justice Scalia, supported by Chief Justice Rehnquist and Justice Thomas. Justice Scalia, in characteristically colourful language, argued that, quote, constitutional entitlements do not spring into existence because some US states choose to lessen or eliminate criminal sanctions on certain behaviour. Much less do they spring into existence, as the court majority seems to believe, because foreign nations decriminalise conduct, unquote. And he goes on to argue that Bowers and Hardwick, the case which is overturned by the majority, never relied on values which the US claimed to share with the wider civilization. Rather, it relied on values deeply rooted in this nation's history and tradition. So again, it seems to be a very strongly worded attack on the use of overseas authority, which indeed Justice Scalia went on to describe as meaningless dicta. This rather echoed his description in an earlier case of foreign fads and moods. Now, one might expect, given this rhetoric, that something really quite unusual was going on in the majority judgment delivered by Justice Kennedy. In fact, though, Justice Kennedy seems only to have introduced references to non-US material in Lawrence as part of a broader package of factors which between them challenged the foundations on which the earlier opinion in Bowers and Hardwick had been constructed. He was not using overseas authority, in this case the decision of the European Court of Human Rights in the Dudgeon case, as being a factor of distinct and special weight in its own right. And we can see this if we look at the Kennedy judgment in detail. Kennedy began by suggesting that the majority in Bowers had misapprehended the claim of liberty presented to it, and he does this by reference simply to previous US domestic cases. To be exact, Griswold and Connecticut, and the development there of a substantive right to privacy. As a result, he argued it was right to say, as commentators have, that one could make fundamental criticisms of the historical premises relied upon in Bowers. It was unnecessary, he said, for the court to reach definitive historical conclusions, but it was clear that the focus, uniformity and enforcement of American anti-sodomy laws had not been nearly as uniform as had been maintained by the majority in Bowers. The historical grounds, he argued, relied on in Bowers are more complex than the majority opinion in that case indicated. Indeed, the opinion was overstated. Now note, this is purely US historical factors which are being relied upon. And it is purely these, he says, which cast doubt on Chief Justice Burger's sweeping statement about the history of such statutes in the United States. Now, it is only after this that non-US authority enters the picture in 2 short paragraphs in Justice Kennedy's judgment, where he argues that the deficiencies in the Bowers majority have become ever more apparent due to judicial and legislative decisions in the United States, but these were supported by the fact that the Bowers majority had been ignorant of European Court of Human Rights precedent on the same topic, decided within the preceding 3 years. So really, the Court of Human Rights judgment is playing a backup role, an explanatory role, no more than that. And yet, this provokes the very, very strongly worded dissent from Mr. Justice Scalia, arguing effectively that the European Court of Human Rights jurisprudence is driving the majority judgment in Lawrence. Now, other than possible exaggeration, I think a further interesting factor which can characterize both the United States and India is the extent to which judges have actually, or courts as a whole, have somewhat switched position on this issue of comparative citation. The example it would be useful to take in the United States is that of Chief Justice Rehnquist. In an earlier case, Washington and Glucksberg, concerning statutes prohibiting assisted suicide, Chief Justice Rehnquist was very happy to use non-US evidence extensively to underscore what he argued was the deeply rooted nature of assisted suicide bans within the United States. In other words, he was deploying, supported by the other dissentients from Lawrence, very much the same tactic that the majority in Lawrence itself was using. Equally, depending upon who is in the majority in the US Supreme Court at any given moment, we can see overseas authority used to different extents. The classic example of this is the trilogy of cases concerning the constitutionality of the death penalty for juvenile offenders, i.e. Thompson, the first case, followed by Stanford, followed by Roper and Simmons. Now the point is, in both Thompson and Roper, the majority was hostile to the use of the death penalty. In Stanford it was favorable. So in Stanford, Justice Scalia is in the majority and is clearly against, with his colleagues, the use of comparative authority, but comparative authorities are mentioned in the other two cases. The Supreme Court itself, therefore, is inconsistent depending upon who is in the majority at any given moment. Equally, we might say, by reference to the history of Indian constitutional law, that the recent Naz Foundation opinion runs strongly against the spirit of cases such as Maneka Gandhi and Union of India, and quite probably, as Thirugendam has argued, the jurisprudence of Justice Bhagwati more generally. There does not seem to be a consistency at the top level within the Indian courts on this issue viewed over time. So there is a clear comparison to be made there between the two systems. That is both inconsistency and, in other situations, exaggeration. How then do we resolve this? Well, I want as the final stage of my argument to draw attention to what I would describe as certain parallel exaggerations on the pro use of comparative citation side of the debate. It's important here, I think, to draw attention to the work of theorists such as Anne-Marie Slaughter or Jeremy Waldron. Slaughter has been keen to talk of the emergence of a global community of courts, of globalization occurring with cross-fertilization in constitutional cases around the world, the cross-fertilization occurring in the interests of efficiency, fairness, and the ends of justice. Awareness of judges in every country that they are engaging in a common judicial enterprise. Now, the problem with these claims made by Slaughter is really that they presuppose a mentality, or even just an ability to describe what judges are doing, which may well be over the top. It seems much more likely, as the close analysis of Naz and Lawrence shows, that really comparative authority is being used very frequently in a more modest role. The idea of a global community of courts seems to be somewhat exaggerated. Equally, Jeremy Waldron's argument that there may be a notion of a global jus gentium idea based on reason emerging may also be assuming too much about what courts are doing. Having said this, I think there is still a very strong place for comparative authority to be used in the sense that courts are, as we all are, ever more aware of what is happening in other jurisdictions. It makes sense in that scenario, so long as we are aware of the local context, to draw upon what is happening elsewhere, so long as it is not the overriding and exclusive factor on which we rely. To return finally to the Indian context, it is therefore worth noting that in her analysis of Indian constitutional law, Valentina Schiotti has drawn attention to the importance of the basic structure doctrine historically as something which is developed with specific focus on the features of the Indian constitution, and therefore as something by reflection to which ideas of comparative authority have to be considered. In that sense, therefore, comparative authority is coming into place simply as something which fits within the existing parameters of existing Indian constitutional law, a technique which I suspect is strongly in accordance with equally Gerald Saunders' analysis of comparative authority. Thank you.
In fact, in this panel, we have 4 eminent constitutional scholars and not 3. I was delinquent at the outset in failing to introduce Tarak Khaitan, who is an associate professor and Hackney Fellow in Law at Wadham College. He is also Associate Director of the Oxford Human Rights Hub. He completed his undergraduate studies at the National Law School in Bangalore between 1999 and 2004. At Oxford, he was a Rhodes Scholar and completed his postgraduate studies, BCL with distinction, MPhil with distinction, DPhil at Exeter College. Before joining Wadham, he was the Pennington Student in Law at Christchurch. Tarrant's monograph entitled A Theory of Discrimination Law is being published by OUP in May this year, so we'll look forward to that. His topic today is transnational perspectives on Indian discrimination.
Thank you, Sarah, and thank you to all the previous speakers for their talks, and thank you to all. Before I start talking about my paper as the organizers hat on, maybe I should explain the references that the previous speakers made to the last 3 days, which might be puzzling to some of you. So for what we've been doing for the last 2 days is we decided to issue, Farhan and I decided to issue a call for papers, mainly targeted to very young Indian law scholars, people who are still doing their graduate degrees, to send proposals. And for the last 2 days we read 9 of those papers, which were produced and circulated to the closed group, and we've been commenting on those papers. So that's the reference that, and it has been an extremely productive exercise, and I hope to the authors as well. Anyway, the second sort of organizer's comment is this session was a residual catch-all session. Everything that didn't fit with the more thematic afternoon sessions was put in here, but I'm pleased to now see that there is a clear line that one can draw between through the 4 presentations, from Cheryl's start on the basic structure doctrine as it's traditionally understood, to Paul's pointing out that there is an external dimension to the basic structure doctrine, in that it has been used in Germany in particular to define the self-identity of a jurisdiction. And I think there's a link to next presentation in when the Supreme Court rejects the use of comparative law because it's not relevant to Indian circumstances. I think one of the ways of framing the debate between the High Court and the Supreme Court is what counts as the Indian context. And autochthony, I think, as self-identity can be seen as the High Court seeing the constitutional basic structure derived morality as self-identity of the Indian legal system, and the Supreme Court taking a very different view on that. My paper follows on drawing upon these comparative themes, but also using Nick's particular example on discrimination law to talk about the Indian development in light of the development in certain common law jurisdictions. I've mainly looked at South Africa, Canada, the UK, and through the UK, EU law, and the United States, primarily because, as far as I'm aware, and I think conversations with colleagues from the civil law jurisdictions have confirmed, common law jurisdictions in particular have taken the lead in the late 20th century in developing discrimination law frameworks. My apologies to the Australians because of my own ignorance of the Australian legal system. That does not find a place in this study, and no doubt other relevant jurisdictions. So discrimination law is in some ways an anti-study in comparative law. An example where, with the exception of the Delhi High Court in the Nas Foundation case, how India has not looked at experiences elsewhere, or at least the more recent post-1970s experiences, not drawn upon that. My suspicion is the reason for that, and this is also true, again with a few exceptions that Nick pointed out, of the US. Now both of these jurisdictions, India and the United States, were the first movers in some senses to deal with the question of discrimination, no doubt because of the most egregious forms of caste and race discrimination that these legal systems had to deal with. So they were thinking about the problem as early as in the 19th century, and started developing an indigenous jurisprudence which took shape in the time to come. But perhaps because of the pioneers' self-confidence, the result in India has been, and I hope show this, an ossified domestic regime crying out for reform, something that the Delhi High Court abortively attempted to carry out in the Nas Foundation case. it is perhaps telling that the other pioneer, the United States, is also increasingly an outlier amongst these English-speaking common law-based liberal democracies when it comes to discrimination law. So comparative law is treacherous business, and I think if there's one message that I hope this paper will give it is that if Indian discrimination law is looking for inspiration and for its own development, contemporary U.S. doctrine is perhaps the last place we should be looking at to see, or if we do, maybe to see how not to do things. But that may not be entirely fair to the U.S. because there's an undercurrent which I'm a lot more sympathetic to. But anyway, I'll stop there. So what I'm going to present is a selective whistle-stop tour of development of discrimination law in these jurisdictions, organized. And what's also special about my choice of jurisdictions is that they've all exported or imported from each other, and inevitably with local adaptations, conscious and subconscious local adaptations. So this is not just a story of discrimination law, this is also a story of comparative law and trans-border travel of legal ideas and concepts. So I've organized the development of the doctrine on discrimination around three broad axes. The first is what duties does this area of law impose? And here we will look at the beginnings in the prohibition on direct discrimination and on provision for affirmative action, and the growth of these new ideas such as indirect discrimination, reasonable accommodation, protection against harassment, etc. In due course. The second axis to look at is who the duty bearers are, who carry the burden of these duties. And again, the narrative is the expansion outwards from the state to the employers, landlords, housing societies, service providers, retailers. And finally, the third axis around which I've organized this development is who is protected, who are the beneficiaries of the law. And Owen Fisk predicted this. He already in 1970s he said that there's been a proliferation of the protectorate in discrimination law, and obviously he had not even seen what was to come in the next few decades, where it really takes off. But let me start with three very early theaters of development of discrimination law. And the first one, I'm even hesitant to call it discrimination law. It's probably the earliest prototype in ancient English common law duty on common callers, such as innkeepers, blacksmiths, and common carriers, to serve all fee-paying subjects without distinction. There's a case from 1701 called Lane against Cotton, where Justice Holt says, "If on the road a shoe falls off my horse, and I am come to a smith to have it put on, and the smith refuses to do it, an action will lie against him, because he has made profession of a trade which is for the public good, and has thereby exposed and vested an interest of himself in all the king's subjects, that will employ him in the way of his trade." Now, this doctrine of the common callers, that they must serve whoever is willing to pay and satisfy the terms, they can't pick and choose, is then extended to all sorts of common callers, including the common laborer and the common prostitute in English common law. Anyway, I call it a prototype duty because it does not look like contemporary discrimination law. The first distinction is that it is not ground-based. Discrimination law today does not impose a general duty to serve whoever comes to you. It says what you cannot do is discriminate on certain protected grounds, such as race, sex, etc., and more on that in a moment. Even so, this general common law duty was relied upon in early to mid 20th century Britain, when in the absence of any statutory protection by Jews and blacks to bring anti-discrimination challenges, primarily against innkeepers. And there's a famous case of Constantine, the black cricketer who was refused lodgings in a hotel where the court relied on this doctrine to say he was wrongly refused the service. The second noticeable thing about this prototype doctrine is that it does not apply to the state. It applies to certain private professionals who hold themselves out to serve the public, and has thereby exposed and vested an interest of himself in all the king's subjects. So although it's non-state, there is a dimension of publicness in the idea of the common callers. Now, outside the prototype, if we can jump to the 19th century, the two parallel developments happening in the United States and in India. So to quickly rehearse a probably quite familiar American history, Dred Scott, 1856, the Supreme Court says blacks, whether free or slaves, are not citizens. Civil War, abolition of slavery, and then the 14th Amendment to the American Constitution, which overturns Dred Scott and guarantees, and I quote, equal protection of the laws to all citizens. There's no mention of the word discrimination. At least then it's not evident to anybody that equality means discrimination, the two go together, etc. And equal protection of the laws could have had a much broader, wider import than anti-discrimination. The very first case that the American Supreme Court decides on the 14th Amendment, the Slaughterhouse cases in 1872, firmly locates the equal protection of laws as an anti-discrimination guarantee motivated, given the historical context, of the protection of black people against prejudicial or hostile state action. Now, this is obviously, so the paradigm is set up. The task of this provision is to protect against direct discrimination by the state against a racial minority. It'll take, the US Congress actually passes the Civil Rights Act in the 80s to extend the protection against discrimination from private persons, which the Supreme Court strikes down as outside its power. It'll take almost a century for the US Congress to be able to do that again. I move quickly to India. We have the Caste Disabilities Removal Act 1850, which is still on the statute books, which says, which requires the courts to refuse to enforce law or usage which inflicts, forfeiture, or affects rights due to religious conversion or loss of caste. But the main action is an affirmative action from the final decade of the 19th century, which has a long trajectory, finally finds place in the Constitution as a consociational compromise between Ambedkar and Gandhi. Anyway, so that's the background. Late 20th century sees a remarkable development on all these three axes, and I don't have much time, so I'll go through it relatively quickly. Most of these expansions are happening in the US first, they travel elsewhere, and then there's pushback and rollback in the US. The first extension, so the key features of this expansion are these. The new statutes that come into play in the late 20th century in the US, UK, Canada, and South Africa, they're all civil in nature, not criminal. There's low standard of proof, and the victim gets something by way of relief. Indirect discrimination is invented by the US Supreme Court in Griggs and Duke Power Company. The concept, to use an Indian example, is essentially the impact of what you've done matters, not your motive. So the focus is on the suffering of the victim, not the intention or motives of the discriminator. So a housing society which says, look, we only want vegetarians, has a disproportionate impact on certain religious and caste groups, which would constitute indirect discrimination. Even if food preference is not a protected ground, religion and caste are, and that would constitute indirect discrimination. There's an expansion of the duty from the state to employers, landlords, service providers, and retailers. There's a proliferation of protected grounds from caste and race and sex to sexual orientation, disability, religion, age, marital status, etc. There's a heightened standard of judicial scrutiny of justification claims. And And at least outside the US, a growing level of comfort with weak affirmative action policies, but which don't nearly approach the exceptional Indian scenario for special foundation reasons. Anyway, in this background, how does Indian discrimination law in the last half century compare? So the law has, the constitutional jurisprudence has largely focused on the scope and limits of affirmative action, primarily reservations in public employment and public education. Article 15 never really took off. There is no recognition of indirect discrimination or reasonable accommodation. There's an extremely deferential standard of review, which is the same as Article 14. So a law that distinguishes between, that puts a higher tax on coffee sellers rather than tea sellers is subject to a reasonableness standard of review. Exactly the same standard of review would be applied if there were different taxes on Hindus and Muslims, which incidentally is, I think, shockingly the case in India because of the legal recognition of the Hindu undivided family as a legal entity. So in effect, non-Hindus end up paying higher income tax than Hindus. Anyway, and the list of protected grounds in Article 15 is read as a closed list, and despite the language of Article 15(2), the duties applied largely to the state and not horizontally. The Delhi High Court tried to undo a lot of this, but obviously that has been reversed by the Supreme Court. The statutory discrimination law in India has not fared much better. There have been a few attempts to extend this to the private sector. The Civil Rights Act of 1955 and the Equal Remunerations Act of 1976 have provisions, criminal provisions, that outlaw certain forms of direct caste and sex discrimination in certain very defined contexts. So we have a scenario where housing societies across the country advertise with impunity, no Muslims, sometimes no Northeasterners, no single women, etc. The Sachar Committee, which looked into the status of Muslims in 2005, came up with a rather bureaucratic response of let's set up another commission to look into it. And the bill that was drafted by the Menon Committee in response to the Sachar Committee's recommendation, the Equal Opportunity Commission bill, remarkably just was entirely about setting up this commission, what it will look like, what its constitution will be, but there was no attempt whatsoever to expand the substantive scope of the law, to develop the doctrine, to say what rights people have. If you don't have any claim of discrimination against a housing society, I don't know what the commission would do. So India's problem with discrimination, I believe, is pervasive and urgent. Of course, Indian conditions are complex and unique, and any solution will have to be located in the peculiarities and pathologies of our local system. But any indigenous response should be informed by what has worked and what has failed elsewhere. I think South African friends tell me that the constitutional protection against discrimination has been remarkable and has done great things, but South Africa's statutory initiatives have not had much of an impact. We need before we do something about it to understand why. And I just finally want to reiterate the need to be suspicious of what I think is an overwhelming and disproportionate influence of American jurisprudence and American literature and American doctrine in this area and others, and there are other places which are less troubled and less divided and less self-conflicted, where we might find more profitable ideas to learn from. Thank you.
Thank you very much. We've had 4 very thoughtful and thought-provoking papers, and now we have time for questions. If you wouldn't mind, please, when you ask a question, just to identify yourself and maybe say to whom your question is addressed. If you wouldn't mind, please, keeping your questions or comments short, then that will give everybody a chance to participate in the discussion. Thank you. Professor Bakshi, I think, has a question.
Open Bakshi, my name, if I may exemplify brevity. which Chair called for. First of all, welcome to you all. On behalf of both Delhi University and Warwick. Well, I concentrate only on two presentations during the want of time. On the first presentation by Professor Craig, I just want to know there are clearly ontological, what you call meta questions involved. What is the being of a nation? What's the identity of a constitution? What is wrong with the older doctrines of margin of appreciation and of subsidiarity, which unfolded quite substantially to do the same job as would seem from the outside, the identity discourse substitute. Whose identity they are protecting? That of the legal order, the constitution, or of the judicial process? That is the main question I have. And the ontological, they're not protecting nation's being, ontology of nation. They're not doing ontology of a population. They're not talking about the Turks in Germany, for example. I'm focusing especially on German court. They're only focusing on their being. The power of judiciary, and in that respect, they're very close to basic structure. Basic structure in India means nothing else than the power of the judges to say what the basic structure is. So that's it, and I welcome it. I am all for it. I want to understand it from you as to what is the distinctive step they've taken from subsidiarity and other things of margin of appreciation. On the next presentation, I think only very quickly, the court should not have heard the second appeal, because the court by written order mandated the Delhi High Court early on to study the matter in all its aspects as it were and pass the judgment. Therefore, what I call Nastu Kaushal is wrongly decided. The court did not come to, Supreme Court did not come to picture because Supreme Court divested itself of the jurisdiction. The PIL was originally filed before the Supreme Court. It gave it to Delhi High Court and it gave direction to consider all aspects and decided comprehensively. And that's what the High Court did. I hope that my lawyer friends will argue with the petition that is now called Supreme Court. What is called? Petition is called curative petition. But coming to that aspect, which I have not noticed, that of reliance on foreign judgments. And I think we bring out the irony very well. The Supreme Court itself relies very heavily on foreign judgments, particularly American. And Supreme Court wanted the High Court to refer to foreign precedents when it said decide comprehensively. So there is a double irony involved in relying on foreign precedents. But my short question is Kaushal decided by the Supreme Court on the ground of insularity or on the ground of severability? That's the question I have. I have not done very far.
Professor Bakshi, thank you very much for the very interesting and excellent question. Very briefly, because of the exigencies of time, my response would be this. There's no doubt that notions of subsidiarity and margin of appreciation are themselves legal doctrines which have an impact on or play into ideas of autonomy. No doubt about that, I wouldn't deny that at all. The answer to your question, which I took to be, why isn't that enough? In what sense do we require more? And the answer to that is, in relation to the UK and the ECHR, it's quite clear that a number of the judges feel that that isn't enough, that that's not sufficiently protective of autochthony as defined in terms of national traditions and national values. And that may not be enough either because the margin of appreciation is regarded as too narrow, or the conception of subsidiarity is not regarded as broad and comprehensive enough. But it's quite clear that in relation to the specific cases where the UK judges have got upset, like the prisoner voting kinds of cases, they do not regard, in that sense, standard doctrines, which do, I accept entirely, play into ideas of autochthony. They don't regard those as sufficiently protective, which is why they're pushing back and wanting more. The second response is that certain of their concerns about the ECHR, whether valid or not, but certain of their concerns are not touched by subsidiarity or margin, howsoever you define those terms. In what sense are they not touched? Because part of their concern, like Lord Sumption and Lord Hoffman and Lord Judge, is about an over-expansive interpretation of the substantive reach of the Convention, which they do not believe is justified, and which therefore leads to an impact on national freedom of action. And that dimension, once again, is not touched by subsidiarity or margin, howsoever defined.
Sure, yes, I think very briefly. And I think the question would be, what is really driving the Supreme Court almost in the